cheating pro se litigants for their due process and equal protection is something apparently that the United States judiciary are actually trained in subverting the equal protection rights, the due process rights of individuals that appear before the courts of the United States without counsel, self-representation, in other words. Falsely claiming, lying, in other words, prevaricating, that New York State doesn't do enough business in North Carolina to warrant asserting jurisdiction and venue over the state in the federal courts in North Carolina is simply it's a lie. The New York State Department of State, the comptroller for the state of New York, provided to me 496 pages, a spreadsheet, an Excel spreadsheet, 496 pages long, comprising 22,000 business trips into North Carolina in a period of 8 years. 22,000. So let's see. What is the minimum in-state contact rule under the case International Shoe versus the state of Washington? That's the question. Now, folks, when you begin to realize that minimum in-state contacts, a couple of hundred would be sufficient. Even less, 100 would be sufficient. But when you're getting upwards of 20,000, 22,000 business visits into the state of North Carolina over a period of 8 years, you're way, way, way past the minimum standards required by the precedent case, the common law case of International Shoe versus Washington State. The rule is sufficient in-state activities, sufficient in-state official state business activities to subject the state of New York to potential lawsuit. In other words, if state officials came to North Carolina and didn't pay their motel bills, or state officials from North Carolina came into North Carolina and had a car accident, or New York State officials came down to North Carolina and, got involved in some kind of a fraud scheme or a swindle where they would be subjected to lawsuit, is more than sufficient. The minimum standards for International Shoe versus Washington State, there is no number on it. Doesn't say 50 visits or 100 visits or 100 or 150 or 200 or 300 or 400. No, but anybody in their right mind understands that 22,000 visits, official state business visits, traveling into North Carolina to conduct all kinds of business. We haven't even gotten into the extent and the numbers, the dollar amounts of this business that they engage in, but 22,000 official state business trips into North Carolina, way sufficient. So when the issue of pro se or self-represented litigants is raised and how they get cheated and swindled for due process and equal protection in the federal courts, I'm working on a real knuckle buster right now. Nose to nose with the 4th Judicial Circuit judges of Virginia and North Carolina, and of course the United States Supreme Court, because the United States Supreme Court's involved in this up to their stinking eyeballs. And I'm talking crooked. Oh my God almighty, is this a crooked game of cheating American citizens for their constitutional rights? Folks, I'm going to leave it right there, and the information and links you need are listed below. Have a wonderful day.